I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, family? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today we are jumping into number 69 on our compilation list. We will be in 3 different judges' courtrooms today for 3 different sovereign citizen cases. But before I give you the rundown on those judges' names, let me first and foremost say thank you for all of your support, everything that you guys have been doing. Keep it up, liking, sharing, subscribing, commenting. All of those good things have definitely been a blessing to the channel, and also has given an opportunity for others to check out some of these proceedings. Now, the 3 different judges' courtrooms we're going to be in on today. First, we will be in the courtroom of Judge Rachel Krause out of the state of Georgia. Second, we will be in the courtroom of Judge Sean Perkins out of the state of Michigan. And last but not least, we will be in the courtroom of Judge Michael McNally, out of the state of Michigan. Also, you already know, no commentary at the end of these. It will be chapters added, just in case you want to jump around. Maybe Sean Perkins, Judge Perkins is your favorite judge. Maybe Judge McNally is your favorite, and you want to jump past Cross to Perkins and then to McNally back to Cross, or whatever it is you want to do. The chapters have been added for your convenience. Now, it's time for me to be quiet and get out of the way, and let's go ahead, guys, and jump into number 69.
Miss Ballard, I'm not going to call your case formally right now. Right now, what I'm looking for is how long do you think that it will take to present what you want to present to the court today?
To my understanding, has the court reviewed the affidavits that has been submitted?
Yes, ma'am, I have.
Okay. So what can I expect as far as procedure? How will this hearing go?
Well, so typically what will happen, because you are the movant, you're the person who's seeking relief. So I would call on you to make a presentation that you would want to make. Sometimes people choose to do that. Some people don't choose to do that. But the idea is that if you wanted to explain to me what your position is in some shorter or different way from how you put it in the filings that you made. And then I would call on Ms. Akpati on behalf of her client to make a response. And then typically, because you're the movant, I would let you have the last word. And then sometimes I rule during the hearing. Sometimes I take it under advisement. It just depends on the circumstances. But if you wanted to make a presentation to outline verbally for me what you believe are the important issues, how long would that take?
I'm not sure. To my understanding, with this hearing, I was under the understanding that the affidavits that have been presented are fully understood, and that based on what I have submitted, that there would be a proper decision and ruling.
Okay, so I'm interpreting that, Ms. Ballard, as you wanting to rest on the materials that you've sent, and that's perfectly fine. Ms. Akpati, what presentation, if any, did you intend to make? I'm just trying to get a time idea of how long this might take.
5 minutes, y'all.
Okay.
From my position, I filed an affidavit of priority interest in the property. I don't understand how we can be at this point when I'm not a tenant and there's no contract for being a tenant. The other party, the opposing party, says that they have interest in the property, saying that they have a sheriff's deed, which is what it's a color of title. It's not the title. There's no position of equity with that sheriff's deed. So to my understanding, with there not being a contract, and I'm challenging the jurisdiction of this other entity, I'm requesting that this motion under the titles, under the Rule 60V, that, this is thrown out. It just, we don't have a contract. There's nothing to really argue here. So I mean, it's clearly displayed and stated in the affidavits that I submitted. And bottom line, we don't have a contract. The other entity does not own this property.
Okay.
I have priority interests and equity in this property.
Okay. Thank you, Ms. Ballard. As I said, I have had a chance to review the magistrate court file and the appeal materials that you filed in this case. One question I did have, Ms. Ballard, is that part of the order that was entered against you, which you are challenging here, right? That the magistrate judges, the purpose of this action is because the magistrate judge entered an order that said that you were not entitled to possession, and that and you're challenging that order. And I understand that part. But part of the order also requires that for you to challenge it, you're required to make some payment into the registry of the court. And my looking at the system, I don't see that any payments have been made. I think that that's part of Ms. Akpati's argument in a brief that she filed a couple of days ago, that you have not made a payment into the registry of the court to preserve your appeal rights. Can you tell me about that? If you have made a payment and maybe I just don't have it in my system, or if you haven't made a payment, can you tell me the basis for that?
I have. They did not ask for rent. They didn't put in an affidavit to ask for rent. So, and there's no contract. But I have paid into the court of registry. The paperwork is there.
Can you tell me how much you paid into the court registry?
All of it. It's on a continuous basis until this matter is resolved. The last month and the remaining balance, everything is in compliance with the order from Magistrate Judge Brooks.
Ms. Akpati?
Your Honor, just to get straight to the point, no payment has been made. I did call the court this morning, and there has been no payment made. So if Ms. Ballard is saying that she has made the payment, could she provide to the court some form of evidence showing that she's made the payment? Because again, as of 15 minutes ago, no payment has been made, or the court is not aware of any payment being made.
Yeah, I have looked in both the magistrate court file, which is often where those payments will go, and I've looked in this action, and the financial documents don't indicate that any payment has been made in either case, other than the original, I think, $103 filing fee that was paid by the defendant in the magistrate court. I don't see anything that indicates payment. I'm happy to follow up with the court because sometimes the clerk gets a little bit behind, but do you have any documentation regarding when you made those payments or the amount of the payment?
It was a couple weeks ago when I filed it into the court of registry.
Okay, what did you file? Did you file like a proof of payment, or what did you file?
It is basically a money order.
I apologize. I need to take a brief break for something. Hold on just one moment. Okay, Ms. Akpati and Ms. Ballard, I apologize for that brief interruption. Okay, so where we are right now procedurally is that there is a dispossessory order that was entered by Judge Brooks on December the 7th. Respectfully, Ms. Ballard, I don't. If you can provide me with some documentation of the payment, I'm happy to pursue that with the clerk of court and find out if there is some issue with it being credited to the wrong file or something like that. But absent any such documentation, there's no evidence that the required payment has been made.
So I tendered a payment into the court of registry. If my payment was not accepted, I would not have received a case number for this Payment was accepted. It had to have been in order to get this case number.
Well,
So
actually,
I have to feel bad.
actually, that's not correct. So the file
that's
indicates,
absolutely.
Ms. Ballard, the file indicates that you submitted an affidavit of poverty, and that poverty affidavit was granted for the filing fee. So you didn't have to pay a filing fee to be able to open this case.
Respectfully, I
Yes,
tendered a payment in the magistrate court.
right. And
Otherwise,
I'm not questioning, Ms. Ballard, that you did. What I'm saying is I need some documentation of that payment because there's no such payment reflected in the magistrate court. And so if you have a receipt, if you have a copy of the money order, if you have even a bank transaction indicating where you withdrew that money from, or where you obtained the money order, that would be some information that I could then go to the clerk and say, hey, I've got a party telling me that they made a payment and there's no record of it. Can you help me find this payment and why there's no record of it?
according to law, I tendered the payment, and I don't know if there's some type of mix up between both courts, but I filed it in both courts. The tender payment is there respectfully. Otherwise, I would not have been able, they even said this has to be satisfied in order to get a new case number for this appeal.
Ms. Ballard, I understand that. All I'm asking is, can you tell me what was the amount? When was the payment? Where did you get the money order from? That's the type of information that I would then be able to go to the clerk and confirm that information. And then they might be able to track the payment and figure out where it went if you made the payment.
All right, can you hold one moment while I get the information? Thank you kindly. Yes, so let me just turn on my camera real quick. Okay, so
yes, ma'am.
I filed a notice of tender payment into the courts, and so to settle this account, I did file a tender payment to the courts, and I'm sure you can see the affidavit in there, and it has proper endorsement. It's been properly endorsed, and if you like, I mean,
Ms. Ballard, can you tell me the case number on that? Is it this case number 2023 CV 390-111, or is it the 23 ED 284-322 case number?
It's 23 ED 284-322.
Okay. Give me a moment to look in the file and see what I can locate. Okay. Give me just a second.
Thank you.
Okay. Thank you for your patience as I've sort of worked through this. Ms. Ballard, Ms. Akpati. I was able to locate the filing that that Ms. Ballard was referencing, which is a notice of tender of payment to settle and close account.
Yes.
And is that the thing you were referencing, Ms. Ballard?
Yes. Yes.
Okay. It was filed in the magistrate court on December the 12th.
Yes, that is correct.
Okay. My review of the notice that you filed. So first of all, I've spoken with the clerk of court, and they have no record of any payment. They have looked everywhere they can think of, including associated with your name, associated with this case, associated with the Superior Court case, and they can find no record of payment. But more importantly, Ms. Ballard, my review of your filing seems to indicate that you are rejecting the acknowledgement that there is that money would be any like it doesn't appear that you actually submitted legal tender of any sort to pay or satisfy this. You instead submitted some sort of signed, some sort of authorized representative document, but no money order, no check, which I don't think they take, no cash, no certified check, anything like that. Is that an accurate statement? Am I correctly understanding what you filed, Ms. Ballard?
I filed a tender payment, and it didn't, I mean, the law says that I can tender a payment. It never stated how to pay it. So, I mean, I fulfilled the contract based on the order. I mean,
Ms. Akpati, other than the motion that you filed regarding the lack of payment and your statements here that there has not been a payment, what is your position on behalf of your client on this matter?
My position is that this matter should be dismissed. The Ms. Ballard has to comply with the order of the court before filing this appeal.
And so I have reviewed what you filed now that I understand what I was supposed to be looking at. And, you know, due respect, ma'am, but it is not filing a paper that says I hereby tender payment that is not actually accompanied by a payment recognizable in legal acceptable tender in the United States. Then you have not made a payment under any legal definition that I am aware of. And so as a result of that,
what species?
Excuse me, Ms. Ballard, I'm speaking, and in a moment I'll let you respond.
So, I mean, on the order, it did not specify how to pay. What species of payment is on there to pay? It was not specific.
I'm sorry, are you saying it wasn't specific in amount or it wasn't specific in method?
In method, yes.
Okay. I disagree. This is a standard order, and the vast majority of everyone I've ever dealt with that deals with these orders understands that when it says tenant must, in capital letters, make the following payments into the court registry by the time specified, everyone understands that I've typically dealt with that means money that is recognizable as legal tender in the United States, which would either be cash or a money order or a certified check. And in the absence of those things being paid, then the court wouldn't have any choice but to dismiss the appeal. And so
I gave you a bill of exchange, which is the same thing.
I'm sorry, ma'am?
I gave you a bill of exchange, which is the same thing.
No, ma'am, it's not. A bill of exchange is not recognized as legal tender in the United States, and therefore it would not satisfy the requirement that tenant must make the following payment into the court registry.
Will you be so kind to confirm under what law?
For that reason, I am dismissing case number.
I mean, ma'am, I object. I object. I mean, it's there. Under what law does it say that it is not a legal payment, a legal tender?
So, in all honesty, I don't know the answer. I could do some research and find the answer, but Ms. Ballard, it's your obligation as the movant to provide the information that the court requires in order to understand your case, to accept your case. And you have not provided me, more importantly, with any documentation or a legal citation that would provide me with some sort of basis to accept your providing me with this note of exchange as legal tender. As I said, my understanding of the law is that a note of exchange is not legal tender recognized in the United States, and therefore it does not constitute a payment.
You have not provided me an answer, but under what law?
Yes, ma'am, I did. The answer I gave you was that it was your obligation. Mr. Freehoff, please mute Ms.
Ma'am, I need
Ballard
to finish what I have to say.
Mr. Freehoff, please mute Ms. Ballard if she's going to continue to speak over me. Thank you. Ms. Ballard, you've been muted because you continue to speak over me, which is disrespectful to the court.
I'm not trying to be respectful. You're
Ms. Ballard,
and not properly.
You are continuing to speak, and Ms. Ballard, stop. I understand that you do not like the outcome. I understand that you believe that that legal tender or notice of exchange that you gave me should count, but it does not. The answer to this question is that the order that was entered says that tenant must make the following payments into the court registry, and there were no payments made into the court registry, and the filing that you submitted does not constitute a payment of legal tender into the court registry and does not constitute compliance with the order that you make a payment into the court registry. And therefore, the case is going to be dismissed. case number 2023 CV 390111 will be dismissed for lack of payment. Anything else that the parties need? Ms. Ballard, you may pursue whatever appellate rights you wish to pursue.
You cannot make a
Obviously, you
ruling over
disagree with
something
my
that
order.
you don't know.
I'm sorry, Ms. Ballard.
You
I
cannot make a
did not hear
ruling
you.
over something you can't know. You saying you don't know is an unacceptable response, respectfully.
Ms. Ballard, as I said, my answer was, if you would like to direct me to case law that says that what you
Is this a
submitted
court of
is
law?
legal, Ms. Ballard.
All right, Mr. Harris, this is the City of Detroit versus Christopher Gray, case number SP 1357945, counts 1, 2, and 3. SP 1191985, counts 1 and counts 2. SP 1629749, counts 1 and counts 2. SP 1267865, counts 1, 2, and 3. And appearance for the record, please.
Sheriff Harris, on behalf of Mr. Gray, please state your name for the record.
Mr. Gray's appearing. I'm here as a special appearance. Mr. Gray's appearing at pro se.
Okay, Mr. Gray.
Okay, strike that appearance. Thank you.
State your name, Mr. Gray, for the record, please.
By special appearance, I'm here to appear for Christopher Lamar Gray.
All right. Today is the date and time set for a show cause. Mr. Gray, you missed the court date, sir.
I apologize. I apologize, Your Honor. I made every attempt to get in. I didn't see my name on the docket when what I assumed was my date. So I don't know how I lost track of that. I do apologize, Your Honor. And
okay. So your name is Christopher Gray. Is that correct?
My name.
That's what you just. Wait a minute. Let me just say what you just said. Let me just say what you just said. I didn't see my name on the docket.
I'm the trustee for the account. So for that.
I'm gonna call you Christopher Gray because that's what we're looking for. And then I'm gonna enter a not guilty plea on your behalf. I'm gonna give you a $0 bond.
Okay. Objection, Your Honor. I would like for the record, I reserve my right not to be compelled to perform on any contract, commercial agreement that I didn't enter knowingly, voluntarily, intentionally, and I furthermore do not accept any liability or compelled or otherwise for any contracts that I did not know that I became a part of because of a license or anything else, Your Honor. So I object, and for the record, the state can't be named a party in this suit. I asked that I put a motion before the court. I didn't get a ruling on that motion. I asked the court rule on my motion.
What is your motion? I haven't seen any motions. What is your motion?
I have a motion to dismiss, motion to strike.
And what is the basis for that?
The basis of that is there is no corpus delicti. The three components there are not those three components. There's only one of the three components here. Okay. The occurrence of loss of injury, that's not here. The whatever happened legally to cause or illegally to cause that loss, that's not here either. So of the three things, the third thing would be me being named. That's here, but the other things aren't here.
Okay.
So
is that all?
Yes, yes, Your Honor.
Okay, your motion is denied, Mr. Gray. All right, now I'm going to set this matter for a jury trial again. Let's see if we can get one quicker. Say that again?
You want to know he had a jury trial?
Yeah, he had a jury trial set for July the 5th, but now it's not been set anymore, right? Let's get a date if we can get a date quicker than that. And for the record, I did not receive anything. Did you get the name? No, I'm check right now. I don't have anything in the file. We're gonna check the mail to see if did you mail that motion in, Mr. Gray?
That motion, one moment, Your Honor.
The motion is denied anyway, but I just want to make sure that we didn't miss anything here. Ms. Mathis, you can check the email to see if Mr. Gray filed any motion.
Okay.
Again, Your Honor, I object. Article 3, Section 2, Clause 2 says that because the state has been named, in cases that the state is named, then in those cases involving ambassadors, public ministers, councils, and those in which the state has been named, those fall under the original jurisdiction of the Supreme Court. So that is my objection, and I put that on the record that if the state is being named, which the city of Detroit would be the state, then this matter doesn't fall in your jurisdiction; it falls in the Supreme Court.
All right. Well, you can put that in a motion or whatever you want to do, but I don't interpret the law that way, and your objection is noted for the record.
Well, I object to you ruling on. I object to you putting in a defense on my behalf. I didn't request that. I didn't put
a defense on your behalf.
You put in a not guilty, and I didn't plead that. So that's.
So you want to plead? You have two options. You have two options. You want to plead guilty, not guilty, or you want to stand mute. Three options. What do you want to do?
I stand mute.
All right, stand mute. And based on that standing mute, I'm gonna enter a not guilty plea on your behalf. All right.
I object to the entering of a plea on my behalf, Your Honor.
Objection is noted on the record.
Thank you.
Well, I'm checking.
All right, let's pass the matter. I'm gonna get another jury trial date, Mr. Gray, and we'll get you out of here. Next time you miss, sir, it's gonna be a cash bond on you. I'll let you know that.
Understood. Appreciate your patience, Your Honor.
Let's do the 527.
You want to add it up
We'll add 2, and we can add it to the afternoon docket, right? Hey, let's do it. Yeah. You know? Huh?
Because they want the people to be here at 9:30.
No.
Jury services.
We'll call. We'll put it on the afternoon.
But I don't know jury services.
We'll call them and find out. All right, let's pass the matter. We're gonna figure out this. We're gonna try to get this sooner rather than later, Mr. Gray. All right, you say the 27th. All right, let's go back on the record with Mr. Christopher Gray. Let's go back on the record for Mr. Christopher Gray. Mr. Gray, I'm going to give you a jury trial date of May the 27th, 2025 at 9 a.m. Okay?
Your Honor,
let's say 8:30.
Your Honor, I think I have in Third Circuit Court a pending case.
All right. Well, what do you have in Third Circuit?
Issue with Land Bank.
You don't have a choice. You come to in person at 8:30. You've already missed the day. You don't have a choice. You have to figure it out.
Okay.
In person, sir.
Will do.
All right. Have a great day.
Thank you, Your Honor.
All right. Still waiting on that appointed counsel, Mr. Lucy. We'll get you out of here as soon as they come.
Thank you, Your Honor.
Let's tell Mr. Gray, before you leave, Ms. Snyder.
Good morning, Your Honor.
How are you? I have Mr. Gray. He is appearing per se. We set a jury trial for the 27th of May. Let's do this. Let's go back on the record with Mr. Gray. Let's go back on the record with Mr. Gray. Miss Snyder, can you put your appearance on the record, please?
Alexa Schneider for the people, P80322. Is this Christopher Gray?
Yes, it is. No, this is Christopher appearing for the account of Christopher Gray.
He doesn't know. He's Christopher Gray at one moment, and he gets confused. Now he's Christopher Gray appearing on behalf.
I am the trustee for that account.
For that
account.
All right. So anyway, Miss Snyder, can you get your officers here on the 27th? Let's say the 27th is a right after the holiday. I know that's short notice for your it's a week and a half. I would like to get this done. Give Mr. Gray his day in court.
I have a few points, Your Honor. First is I will not be here on the 27th. So I would have to ask that we not set a jury trial on that date. I wouldn't be able to get anyone to cover. So I could not have a jury trial. I would object to setting it shorter than the 2 weeks without having the chance to talk to the officers. If they were here in person or on Zoom, I could ask them, but I just don't know their schedules. They might be on furlough. They might have medical issues. And third, I would object to Mr. Gray representing anyone, be that an account or another person. Since he is not an attorney, he cannot represent anyone.
All right. I'll rule on I'll hold your objection in abeyance, and I'll rule on them on the end of the jury trial date. Ms. Mathis, please. June the 10th can't be. All right, June the 24th. June the 24th, 2025. That's going to be in person. We're going to set a final pretrial date for the day before that, for June the 23rd, 2025 at 8:30. That's all the parties need to appear. They do not need to appear in person. You can appear on Zoom, but we want to make sure that at least we have some officers that are going to testify and to give testimony for the people to make see if they can not to make the out see if they'll be available for the trial the next day, so we don't inconvenience the jury. So a jury trial is the 24th of June, 2025 at 9 a.m. And a final pretrial is going to be June 23rd, 2025 at 8:30. And that jury trial is going to be in person. And then all parties must appear for the June 23rd final pretrial date. Understood?
Is this for all of the charges on the docket, Your Honor?
Yes, this is for all the charges except for the civil infractions. We're not entertaining those at all.
Thank you, Your Honor.
And he maybe some more. No, it's all. I think I counted 10, and I counted 10 into the record. All right. Anything further from either party? All right, hearing no response. Everybody
Yes, understood.
All right. Hearing no response. Have a very good day, and best of luck to you, Mr. Gray. And
thank you, Your Honor.
Candace Leslie Langmeyer, 25B82433A, B, and 82434. Might as well call up your co-defendant too here. James Robert Adams, 25B82370A, B, and C. Your name, ma'am?
Candace Leslie Langmeyer.
All right, so you're charged with running the dog running at large. You're also charged with 2 counts of that, and no dog license. Your name, sir?
James Rob, Special Appearance, James Robert Adams.
All right, how you doing, Mr. Adams?
All right, sir.
All right, you're charged with dog at large, and no dog license as well.
Mm-hmm.
We have, let me see here.
I think you
have another charge. You have also 25B82371. So you have 70A, B, and C, and you have 82371. And ma'am, you just have 3 charges here. So each of you have the right, let's see.
I reserve all my rights, sir.
Each of you have the right to, what's that?
I reserve all my rights. I don't want a jury trial.
You don't want a jury trial?
I do want a jury trial. I reserve my rights. I want a jury trial.
All right, let's slow down. You have the right to a lawyer for arraignment here today. Do you want a lawyer?
No, sir.
Do you want a lawyer?
No, sir.
All right. On November 24 of 24, he's alleged.
If it was something I could handle this matter today with whomever, I would be willing to do that.
I'm not gonna, I don't have anything to do with that. I'm just gonna arraign you and send you to the prosecutor.
Absolutely.
So you have a dog roaming at large on Langdon, it says, versus near Eric. Both of you do. This is the same charge. It's November 24 of 24 at 12:19 a.m. So each of you have 2 charges of dog at large, 1 charge of no dog license. That's a civil infraction. The dog at large charges are punishable by up to 500 fines, 90 days jail, costs are all of those. And the civil infractions are punishable by payment of fines and costs only. You also have, Mr. Adams, another charge for some reason. Let me see here.
I don't even know what that's called. I don't think I have that one, to be honest with you.
You have another charge of, you have 2 dog license required charges. So it looks like they just issued, I'm sorry, ma'am. So do you. You have 82434. So both of you have 2 dog at large charges, 2 dog license, no dog license charges. Those are civil infractions. Both of you have 2 of those each.
So, Your Honor, may I speak for a second?
Depends what you're going to say.
So this is you seeing her. It's been over a year, I think.
Actually, if I can speak.
Go ahead.
Okay, so as of June 22nd, 2023, when I came for a violation of probation.
In front of me?
In front of you, yes, sir.
Multiple times.
Yes.
I remember it well.
Right, so that day when I was here in court, we had come to an agreement with the prosecutor, with our lawyer present, that from that day forward, he has full responsibility. It was known to let animal control was here as well. So as of that day, he took on full responsibility for the dogs. I was no longer to be contacted, just so I didn't have to be.
You can talk to the prosecutor about that.
Okay.
I know nothing about that.
Okay.
Yeah.
All right.
But those are the possible penalties. So I want to make sure you understand it. Do you understand it, Mr. Adams?
Absolutely.
Do you, Ms. Langmeyer?
Yes, sir.
And did you sign, read, and understand an advice of rights form, Ms. Langmeyer?
Yes, sir.
Mr. Adams?
Yes, sir.
So I just want you to know, if you plead guilty at any time, you'll be giving up all those rights, and there will be no hearing or trial. Do you understand that, Ms. Langmeyer?
Yes, sir.
Mr. Adams?
Yes, sir.
All right. Do you still wish to waive your right to a lawyer, Mr. Adams?
Yes, sir.
Ms. Langmeyer?
Yes, sir.
Give me 1 second here. I just got to get this. All right. Okay. So you guys can go and talk to the prosecutor.
Okay.
I don't remember what kind of dogs they are.
Well, I have a new one, so I used to have an old one. He passed away.
I'm going to give you a personal bond of 500, but I'm going to add the conditions when you come back here. Okay? So I'll enter not guilty pleas for both of you. You can go and talk to the prosecutor. The dogs, actually, whatever dogs, how many do you own now?
I have 2.
What kind?
One is a coonhound, a Walker coonhound, and the other one is a mastiff.
So they either have to
Mix.
be in your house, in a fenced-in yard, or on a leash equipped with a muzzle accompanied by you. That's a condition of your bond. Do you understand that?
I do. I have one question.
Hang on one second. Do you understand that?
Yes, sir.
Okay, what's your question?
My question is, so the last time we were here, I actually had a fence, like it was an invisible fence. It's not very good. They fail. So what I did buy is I have a GPS collar here. That's what I have GPS collars that are electronic fences.
I'll tell you what I'm going to do.
So
We're going to talk about all this when you come back in after you talk to the prosecutor. Maybe you can mention to her what you did, all
Yeah.
right?
Okay.
And I'll call all these cases when you talk to her,
Okay.
and we'll go from there, all right?
Okay.
But we'll talk about the bond conditions. But as of right now, what I just said are the bond conditions. If you got some reason to ask me to do something different, I'll be glad to listen, okay?
Okay.
Thanks. All right. Did you meet with Ms. Langmeyer and Mr. Adams?
I did, Your Honor.
What are we doing on that?
We're scheduling it for jury trial. I would also like to address bond when appropriate.
James Robert Adams, 25B 82370A B C. Hang on one second. Seems like I'm missing a ticket maybe now. A, B, and C, and then Langmeyer, Candace Langmeyer. 25B 82433A B C, and there's also 834 behind this as well. So we have, just for the record, I don't know if you saw it, Ms. Foley Carter. We got 2 counts of dog roaming at large, 2 counts of no dog licenses to each defendant.
Correct, Your Honor.
I had told your name, sir?
James Robert Adams.
Ma'am, your name?
Candace Leslie Langmeyer.
I had told them before that I wanted the dog to remain in the house in a fenced-in yard or on a leash, accompanied with a muzzle. He talked about some other thing he had.
It's a fence. It's a GPS fence. That's kind of like the new state of the art.
What do you want to say, Ms. Carter?
Yeah, well, first off, whatever collars he has, if they are fixed with these collars, they're not working. The dogs are in the road, bothering joggers, bothering other people that are walking their dog, defecating on neighbors' property. They are houses down yonder. This has been going on for years now.
I know it has. Ms. Langmeyer was in front of me on a multitude of cases, so much where I actually threatened jail on this because you can't keep letting dogs run around the neighborhood, folks.
If they were out of the yard, we were there with them and they get back in the yard.
I'm just telling you.
I'm just, they don't like run loose. We're there. Now we're there. Now, before my boys would let them out, I don't even let them out anymore. I am there. So and that's why I want to see the video. I need to see what there's.
Well, here's what I'm doing.
Larry across the street has been creating issues, not just with me, with every other neighbor. And he's also surveillancing my property.
Hang on a second.
Which is against the law.
Hang on. I just can't believe it's coming to this again. I saw these up today.
I spent thousands of dollars.
Hang on. I just can't believe we are still going on and on about these dogs.
They haven't hurt anybody.
Maybe they haven't. They can't run the neighborhood.
They're not. I'm telling you, if it's 1 or 2 times.
Look, I don't know that they were not on this.
I need to see the evidence.
Yeah,
Your Honor. I really do. I need to see it because as far as I know, they haven't been.
All I know is this. I had multiple cases. I don't know if this is this your wife or girlfriend or what. I don't care. But with Ms. Langmeyer, I had multiple cases with her.
Yeah.
Multiple cases with her. So much so that I actually was threatening to send her to jail on dog at large, which I've never done and never threatened anybody about jail. And actually was serious about sending her to jail because I had multiple cases and complaints from neighbors, it sounded like. So now here I am 2 years later back dealing with dog at large cases again. I'm just telling you, I'm going to give you your trial, but just remember, There's no defense to this except the dog it can't be running around the neighborhood. That's dog at large.
I don't know
Hang
that it
on.
has been.
I'm not saying they were.
That's why we-
I'm just telling you guys, I'm sticking with the bond conditions I just gave you. Dogs to remain in defendant's home, fenced-in yard, or on a leash, accompanied by the owner and equipped with a muzzle. That's it. That's the order of the court. And you're not to have any contact with prosecution witnesses at all. Now, I'm going to give you your jury trial. We'll set it up now if you want. But those dogs, look, I don't know what kind. You told me what they were. Didn't sound overly well. The Mastiff isn't exactly a little dog. Those dogs are huge.
He's a mutt. He's not that big. He's
not that big.
about the same size as our coonhound.
I don't care,
He's 2 years old.
folks.
He's a puppy.
There are laws and you got to comply with them. And I just think it's silly that we've gotten to this point.
It is.
Just please listen. Yeah, but this has been going on for years. Maybe not in the last two. I don't know. I heard you had a case with Judge Heston, didn't you, Ms. Langmeyer, a year or so ago on one of these?
No.
Are you sure?
I think,
It did, Your Honor.
No,
It was ultimately dismissed and issued against Mr. Adams.
No, I know.
Oh, yeah,
Well, I'm
that's
just
what it was.
saying,
yeah, that's what
I haven't
that's
had
what it
you in
was.
front of me in at least 2 years, probably, Ms. Langmeyer.
Yeah,
but-
so it was in front of Judge Heston then in
Yeah.
June of 23. Yeah.
And
So
correct.
I'm just telling you that you can't.
If my dogs have done any damages or do anything wrong to
They
anybody,
don't have the right to run through the
as
neighborhood.
far as I know, they haven't.
Okay.
That's what I need to
Well,
know.
they have to prove that. They have to prove
Yes,
it. They
I
have
need to
prove
know
it.
that. I mean, I can't. Larry, the guy across the street's half nuts. He's 80 years old. He's surveillance my property, surveillance in my next door neighbor's
Taking
property.
pictures of the kids.
And then he's actually some of those issues, those tickets. I went and
How old
looked
are
at
you,
them.
Mr. Adams?
How am I? 51.
Then you're old enough to know that life is awful short and this is silly stuff that we're
It's
talking
It
about.
is.
It's insanity.
It is. And I tell you what, if my dogs do any damages to anyone, I'll make them whole again.
It's not the point.
You know what I mean?
Can't
I
have
don't-
dogs running through the
They're
neighborhood.
not,
They don't
though.
run
They're not.
through
That's what I'm saying is that I don't know that they have. I don't know of any since.
Okay, so she's gonna have to prove her case. I'm gonna give you guys those bond conditions. I expect you to comply with them. I'm gonna give you a pretrial date. You're gonna come back. If you choose to resolve it then, great. If you don't, that's fine. We'll set it for a jury trial, okay?
Yes.
I don't have any problem with that, but just remember, just for whatever it's worth, awful tough for a lawyer to win or for a non-lawyer to win a jury trial. I know everybody thinks this business is easy.
It's not.
It's
No,
not.
easy.
And I'm just telling you, you have every right to represent yourself. I'm not going to deny you that right. You can sit there and play Perry Mason all you want. I'm just telling you, it's awful hard for a non-lawyer you don't know what you're doing, even though you think you do. What day we giving, Lisa? Write it down. February 12th at what time?
10.
And then we'll set it for a jury if it's not resolved. Think about what I'm saying, Mr. Adams.
Yeah.
All I want is the dogs to remain in your yard or in your house or on a leash, accompanied by you or your wife or girlfriend or other suitable owner and equipped with a muzzle. That's what I want. That's what's going to happen now. What else do you have to say, Ms. Foley
I
Carter?
just want to clarify 2 points about their bond. I know that it said that the dogs need to remain in a fenced-in yard. I know they seem to believe that the invisible fence is sufficient, but it is not.
We have.
I would
we
ask
have
that the
halo
dogs remain on a
collars.
tether or leash at all times.
They have.
Additionally, for prosecution witnesses, specifically Larry Krasinski, I don't want them to have any contact with him or go back to his home. They did post something on his property after the animal control officer.
Hang on a second. Let's take one thing at a time. You just got done telling me, Mr. Adams, I thought, please correct me, did you not say that doesn't always work? The fence, the invisible fence?
We got.
No, it's the wireless ones that you put in the ground.
That's why we got them these halo
That's why I got them the
collars,
halo ones.
GPS collars.
So the one.
Well, it must
the
not
wire
be
bricks-
working, or at least if you
So-
had it, listen to me.
I couldn't.
If you had it November 24th, the dog would have got out of the yard, right? If it was working.
If
They think that the dog was out of the yard on November 24th.
I want to see if maybe my kids let them out and they didn't put the collars on them. They don't wear them
How old
24
are your
hours.
kids? I've heard this story about your kids.
13 to
before.
16 now.
Well, they
13 to
need to
16
be trained.
Yeah.
That dog has to either be in a cyclone fenced yard, in your house, or on a leash equipped with a muzzle and accompanied by you or another suitable adult.
Correct.
That's it.
Okay.
I'll see you guys here on the 9th. What are we doing? The 12th at what time, Lisa?
10.
12th at 10. Will you write that on those files, please, Lisa? I gotta
February 12th?
February 12th. And if we don't resolve it then, we'll set it for a jury trial.
Okay.
But you guys, I would encourage you to try to get together. Wait a minute. What else did you mention? You don't want him to have any contact with who?
Larry Krasinski.
Krasinski?
Yes.
How do you spell their last name?
It is KORYCIN.
KORYCAN.
CIN. SKI. And that's returned to his home.
Yeah, can you read this?
Wait a minute. What's Larry Krasinski have?
He's surveillancing my property.
Wait a minute.
He is the.
Wait a minute. Slow down. Was he the one that made the complaint about the dog being at large?
He is, Your Honor.
Okay. Well, that's okay. That's fair. No contact with Larry Krasinski then. I think that's fair.
Yeah.
You don't want to have
We'll just put
contact
that.
with him anyway.
No.
Yeah, but I did write him a letter. That was what I was supposed to do.
You already sent it.
Well,
Yes.
I walked it over there,
Well,
knocked
we
on
did
the door to hand it to
To
him.
hand
He
it
was
to
home.
him. That's what we did.
What day was that? I have it written down. 12/30/2024.
12:30. And then,
Well, that isn't a bond violation. You've already done that.
Correct.
I didn't
Yes.
have that bond in effect. then.
Correct.
Now I do. So now you can't deliver any more letters or call them or write them or see them or text them.
That's all we had to do.
that was what we were supposed to by law.
Come on, guys. Let's get this in order, please.
Yes, sir.
We'll see you here in a couple of weeks. Have a great day.
Yes,
Go
sir.
down the hall, get your notice. Thank you.
Thank you.
I'm not threatening you. Say one more word and that's 30 days. 30 days.